Hello, welcome back. This is Roger Royce with the 10,000 Startups Podcast. I'm a partner with Haynes Boone in Palo Alto, California. And each week we give you original content on an issue of interest in startup law. And this week is going to be kind of a fun one. We have the title of it in the popular press has been "Can You Copyright a Vibe?" And it's about, I guess, feuding social media influencers, which is always fun. Our guest today is Michael Lambert. He's an associate in our intellectual property practice group in the Haynes Boone Austin office. He focuses on media, entertainment, intellectual property, and First Amendment litigation. And he has been recognized by best lawyers as ones to watch. So, hey, Michael, thanks for being here. And why don't we get started? Tell us about the case that we're going to talk about, which originated, I guess, in your neighborhood in Texas, right?
Yeah, absolutely. Thanks for having me, Roger. It's really a pleasure to be here. I'm glad you invited me on. It's a really interesting case. So, yeah, it was filed in the Western District of Texas, which is in Austin. So, the case involved two social media influencers, and they both promote Amazon products on primarily Instagram and TikTok. And really, the gist is that one influencer alleges that the other has used her likeness without permission and created similar content as hers to create her own products. So the plaintiff's name, her name is Sydney Nicole Gifford. She has about 1,000 posts and about a little over 300,000 followers on Instagram, just to get an idea. So she's like a micro influencer. She isn't like a major influencer. She's not a household name, but she does have somewhat of a following. And she's been known for promoting Amazon products, and often in her posts are very like clean aesthetics, so very like beige, neutral colors, and very fashionable. And she kind of is sort of she's a young woman, so she's very hip in a lot of women's fashion, and that's sort of like her brand, and that's sort of what the vibe is of her content. Well, there's another influencer. Her name is Alicia Sheil. She's also from Texas. She has about 1,000 posts on Instagram and about 140,000 followers on Instagram. And she promotes Amazon products. She talks about them, the pros and the cons, and kind of does her own reviews. And she's also like a young woman, very stylish, very fashionable. Similarly, kind of likes beige, not vague, neutral colors. So their styles are very similar. And I think because of that, they actually met twice and they decided to meet in Austin to share ideas, right? You're influencers, you want to learn about what another influencer is doing. So we don't know a ton about these interactions, but what did happen is after the second interaction, Sheil actually unfollowed her Gifford on social media, which as you may or may not know is a big sin in the social media space. So subsequent to that is when Gifford filed this lawsuit against Sheil, and I can get some more details about the claims of the lawsuit. But that's sort of the background about who these two women are. So they didn't know each other; they're not complete strangers, and they had similar styles. And basically, Gifford is saying that Sheil basically, mooched off of her and used some of her ideas in her own post, and is basically kind of making money off of Gifford's, style.
So, what is the exact claim there? It sounds like, oops, just so I understand, two social media influencers, one is sort of copying the other one, I guess. What's the legal claim involved? Why can't you do that? Why is that a bad thing?
Yeah. So the plaintiff Gifford actually brought 8 claims. I'll go through them and then I'll explain a little bit about them. So the first claim is direct copyright infringement. The second is vicarious copyright infringement. The third is trade dress infringement, which is a part of trademark law. And then the fourth claim is misappropriation of likeness. I think those are really the four strongest claims. She also brought a tortious interference claim, an unfair practices claim, unjust enrichment claim, and a claim under the DMCA, which is the Digital Millennium Copyright Act. So it's a fair amount of claims, and they're all a little different. The basis of the copyright infringement claim is basically that Gifford made copyrighted work, and that Sheil had access to it and created a work that was substantially similar. That is what's needed for a copyright infringement claim. So that's one of the main claims, but there's 8 total, which is a fair amount of claims there.
Okay, so I understand understand the claims. One is copyright infringement. This is mine, and you copied it, and you're not allowed to do that without my permission. There's a misappropriation of likeness. I guess that's something like trademark or trade dress involved there. There's an
Right.
unfair competition claim in there probably because that just kind of here, at least here in California, that just doubles up on any other claim basically. So what happened next? Claims are made. Um,
Right.
did she say, okay, you caught me, I give up?
No, she's really vigorously denied the allegations, and really just said that these were her own creative ideas, and that these were all original to her. So Sheil filed what's called a 12B6 motion to dismiss, and basically what you're alleging in a 12B6 motion is that the plaintiff did not allege facts to create an actual viable claim. Like the facts, even if you take the facts for face value, they're not enough to make an actual claim in the law. But interestingly enough, she did not file a Rule 12B motion in defense of the direct copyright infringement and trade dress claims, but she did for the other claims. And a Rule 12B6 is some judges, many judges look at those, really giving deference to the plaintiff, and it's unlikely often for a judge to really grant those unless they really don't think that there are any facts that could potentially lead to a claim. And if a 12B6 motion is denied, usually what happens is the parties will enter into discovery where they'll learn information about each other, they'll exchange records, they'll exchange information, and likely have depositions and learn more about those claims. So the 12B6 is sort of a screening process in the front of a claim to make sure it has enough plausible facts to make a claim.
Gotcha. Okay, well, what did the court decide?
So as actually a magistrate judge, in the Western District of Texas, it's pretty common for magistrate judges to rule on dispositive motions. Actually, the Western District of Texas is records served, and what I've heard recently is one of the most busiest courts in the country because we haven't had a new judge in a few years appointed because of the politics of the two parties at issue in Texas. But anyway, so there was a magistrate judge, Dustin Howell. He did recommend the dismissal of the tortious interference, unfair competition, and unjust enrichment claims, but he allowed Gifford to pursue the vicarious copyright infringement claim, the DMCA claim, and the misappropriation claim. And I can get into a little bit if you would like a little bit more about his reasoning for those rulings.
I think I would. Let's take those one at a time. So what is vicarious infringement?
Right. So for vicarious copyright infringement, you need to first prove that there was a direct infringer, a third party besides the defendant that committed copyright infringement. And then you have to allege that the defendant had the ability to supervise over that conduct. Those are the two main elements. And what was really tricky about this vicarious claim is that the theory is that the social media followers of the defendant were the ones committing the direct infringement, which is not really how we usually think about direct infringement, because to infringe, you have to have access to work and actually copy it and either reproduce it, create a derivative work of it, display it, or some other way make a copy. So this was and the judge admitted this was a pretty novel theory, essentially, that basically like a social media an owner of a social media account can be found liable for vicarious copyright infringement, basically for the infringement of their users. So it's very interesting theory there that I'm not sure and don't anticipate surviving the next steps, but we will see.
So that'd be like if I were to repost something that was infringing, that's the vicarious infringement that the original poster would have liability for.
Right.
I think I get it. Okay, what was the second one you said?
So there's DMCA, and then the DMCA claim is another one, the Digital Millennial Copyright Act, which basically the DMCA was meant so that folks don't disguise copyright infringement. So it's a separate cause of action that you can bring against somebody if they remove or alter what's called copyright management information, CMI. Typical CMI is the copyright registration mark or the copyright name, but there's other indicia of showing that somebody is an author of a work that can be considered CMI. So to make a DMCA claim, you have to show that the defendant intentionally removed CMI in order to conceal the actual infringement that was going on. It's a very tough claim to make. At trial or on summary judgment because it's hard to show that somebody actually intended to remove that information. Maybe they did it on accident. People remove copyright information on accident, but it's really hard to prove intent. So even though that claim was survived the motion to dismiss, it's going to be really hard pressed for Gifford to find facts in discovery that Sheil intentionally removed CMI.
Yeah, and to be clear, what the magistrate didn't decide the case. They didn't say, "Oh, you're right" or "You're wrong." They just said,
Absolutely.
"These claims, forget it. There's no way. Even if we assume all the facts in your favor, you can't prevail on these claims. But these claims, there is a universe in which you might prevail if the facts are as you say, right? So that means it goes to the next step."
Right. And actually before that, so a magistrate judge, so what he issued was called an R&R, a recommendation. So, and actually the district court judge basically had to review that, and both parties filed objections against the R&R, but the actual district judge, Judge Pittman, adopted that R&R. So just throwing that out there, Judge Pittman didn't really do his own analysis at all, which is fairly typical, but it was adopted the R&R was adopted, but as you say, it's still very early in the case.
Yeah. So nobody was happy with that decision, meaning it was probably
Right. Right.
And were any other claims survive the motion to dismiss?
So the misappropriation claim also survived because the allegation there was sort of that Sheil was using Gifford's likeness by using similar outfits and hairstyles and makeup. In the complaint, it's actually interesting. The plaintiff Gifford had like dozens of posts side by side showing the similarities. And when on a podcast like this, it's hard to really see that. It's easy to look at this case and be like, this is kind of baloney because people copy people's styles. But when you see 60 or 70 posts side by side that are, they're not exactly the same, but they're similar in style, it does make you kind of wonder. And I think that's probably where the judge came out on this. Because, there are just some where they're both wearing the same article of clothes in the same exact way. And the defendant posted it after the plaintiff. And, the plaintiff also basically alleges the defendant is sort of like obsessed with her in a way, so much to where she got a same kind of tattoo on her arm. Like that's how similar these women have sort of modeled their career. So even though that's not part of the claim, she included that in the complaint that months after she got this flower tattoo on her arm, the defendant got a very similar one. So that just kind of goes to show you the similarities here.
Wow. Well, so now we got to wait for this to go to trial, I guess, and for them to develop the evidence. But let me ask you, even though it's early in the case, what are you? I mean, you practice in this area, you do IP, you do social media stuff. This sounds to me like a really big deal because if that's right,
Right.
everybody's going to be looking. I mean, except for me, nobody's going to be imitating me, but the influencers are all going to.
You never know. You never know, Roger. Don't sell yourself short.
So what do you think about this decision?
It's been interesting in, district court decisions that don't involve big issues like executive orders or constitutional law issues, or they don't make the headlines. They're just kind of buried until they percolate through the courts. But this case has been everywhere. This has been written by the New York Times, Vogue, PBS, People Magazine, and that's just like the news media. The legal publications have written about it from all parts of the country. And I think it goes to your point where it's like, wow, if you really can make a cognizable claim based on this facts, there's going to be issues there and there are going to be concerns. And it could, there's the fear that it's really going to stifle speech and really just kind of make people pause when they create stuff if, you can be sued for creating posts that are just sort of similar to others. And, Roger, as you know, as a lawyer, when you're sued as a defendant, it's a lot of, but it's a lot of stress, but it's so expensive. Even if Sheil does end up prevailing, it's going to be a lot of money and a lot of stress for her. So going forward, if, other content creators are able to threaten claims against content creators that they may not like, that they think are copying their style, I think that's sort of alarming. And for creativity, much less just kind of the law and what these laws were designed for. As we all understand, copyright law and trademark law were written 30, 40 years ago. They're not written for now. So judges are trying to kind of fit those principles within today's landscape, and it's difficult in these situations.
Yeah, and you know what else is interesting is that this case arose in Texas because it's
Right,
the kind of thing that I would expect to come out of California, where
right.
first
Or
of
New
all,
York, right.
yeah, one of the coasts because that's where you see a lot of the content creators, and really that's where you see sort of these novel extensions of the law. But this was right there in the heartland.
Yeah, but
Um,
Roger, to your point, it's so interesting, obviously there's still the most content is created in California and also in New York and big cities. But because of influencers and social media culture, there are people creating content all over the country in ways that they didn't as much before. And people used to take photos all the time, but now they're all posted online, so you can go on there and see other people and. Maybe you can make a copyright infringement claim. So there have been more claims, not only because there's more content, but because the content is more visible to others because of the internet.
it's interesting that this is mostly phrased around copyright because I'm old school. I think of copyright. I think of books and records. You probably don't remember when records were actually records, but I think of artistic or literary expressions. It's a little hard for me to get my brain around the fact that that can extend to something like a style or an image. But I think the law, what I'm hearing is that the law must be fairly settled that it does cover those sorts of things, right?
Yeah, I mean, copyright law protects photos and videos, and that's what it was at issue here. And the standard, which I think is going to really be important, is a substantial similarity. So, the defendant didn't use the exact post and photos and videos of the plaintiff, but the allegation is that they are substantially similar, and that's a tough line to find. You have to also find that the defendant had access to them. I think here access is relatively easy to prove because they're on social media and they did follow each other and had met. But the substantial similarity is really, I think, where the rubber's going to meet the road.
How about, let me ask you, what about some of the state law rights, property rights that are involved? You've convinced me that there's a copyright issue. I think you said earlier maybe a trade dress, but you also mentioned some state law. You said misappropriation. Um, what is the standard there? How does somebody develop rights under state law, or is it completely federally preempted?
Yeah, so the judge actually found that the unfair competition and the unjust enrichment claims were preempted by the Copyright Act. So Section 301 of the Copyright Act basically say that if a claim falls within the general scope of federal copyright law, that is preempted. So that was not a total surprise. But the misappropriation claim did survive, and it's a little different because it basically alleges that you have some sort of likeness, and it doesn't have to even be a photo of you. It can also be kind of like your voice or your mannerisms or your style. That there's some value in your likeness, and somebody else used it for a commercial purpose.
Is
That's
that
the
what we would
difference.
call a right to publicity?
Right, exactly. Yes.
Okay.
Misappropriation and right of publicity in some states are synonymous, in some states they're a little different. But here in Texas, misappropriation is essentially a right of publicity claim. Yeah, exactly right.
Gotcha. And I guess the last question I'd ask you about this is we kind of skated over the jurisdiction issue, but again, I got to come back to this. Why Texas? Why was this thing sued there?
Well, Alyssa Sheil lives in Austin, Texas. And Gifford used to live in Texas, but has moved. But the defendant lives in Texas. So I think the idea was that she could, there was personal jurisdiction over her in Texas. So I think that is why the claim was brought there.
Okay, so it wasn't because, gee, the Texas courts, recognize this right and other courts don't, or anything like that.
Right. I wouldn't think so. Copyright law is relatively agnostic as politically, unlike some other types of laws. I wouldn't think there was forum shopping because they thought they would get a better shake here. I mean, but if this does, if there is precedent set and the Fifth Circuit adopts precedent that does allow these claims, then it could become a forum in which, folks would like to bring claims. But at this point, I don't think that that was the reasoning.
Yeah, I would think that would usher in a flood of litigation. That's just my view. But what do I know? I don't spend as much time on Instagram as most people. At least that's
You
what I
saved a lot of time. Absolutely.
All right. Well, with that, I want to thank you. This is Roger Royce. I've been speaking with Michael Lambert, who is with Haynes Boone in Austin, Texas, talking about the case of Gifford v. Sheil. Can you copyright a vibe? Fascinating case. We'll keep a strong eye on it, I'm sure, to see how it develops. And we'll stay tuned. And we might have to have you back, depending on how this case goes. But again, Roger Royce, 10,000 Startups. Thanks, and we'll see you all next week.